everyone fared okay last night in the Seattle area with that big storm. Hopefully, if you're here, it's because you have power. I do know it's slowly coming back. We just got ours back. So thank you for joining us today. We'll just jump into it with our normal housekeeping and instructions. Please remember to keep yourself on mute. Unless you have a question, you can also put questions in the chat. But remember, the chat is for questions and not intended for basically a discussion or commentary. The chat is also not legal advice, and everything we say today is not legal advice. If you would like legal advice, you should contact your association attorney. Don't take things from this Q&A and try to use them as legal advice. And if someone comes to you and tries to say that, well, condo law said this, you can tell them that it's not legal advice. And we are still getting a lot of questions about the Corporate Transparency Act. National CAI did file for an injunction, which they lost. And so all boards should comply with the CTA. There is no current exception for associations at this time. There are bills introduced in both houses of Congress to delay or exempt associations. So if you are very passionate about this, you can try to lobby your senator or representative. But again, as of right now, compliance is mandatory by December 31st, 2024. It's pretty easy to do. We had to do it, or Ken and Valerie had to do it for the law firm, and it's not as daunting as it seems. It will take time, but it is pretty easy if you have a computer, and you can go back and watch some of our past Q&A videos for lots more information about the CTA. The bottom line is you have to do it. It's not that big of a deal. It's just going to be another thing you have to do, but it shouldn't take very long. Another reminder, as we are now well into November, almost into December, is remember to give yourself enough time to get your budgets ratified before the end of the year if you want to be able to increase your dues starting January 1st of next year. We will be talking a little bit more about that later in the Q&A, but again, if you want to increase your dues so that on January 1st, the dues increase, start planning now, because it's too late to have been starting planning last week, which would have been even better. Basically, it's time to get on it. In the chat is a link to subscribe to the Monday Morning Minute, which is put out by the WSCAI LAC committee, so Legislative Action Committee. Chelsea just put in the chat. This will give you short blurbs every Monday during this next legislative session so that you can be aware of what is going on in Olympia this next session and how it relates to community associations. Probably Valerie will give a better update of what's happening at the next Q&A, which will not be next Wednesday. We are canceling the Q&A next Wednesday, November 27th, because it's the day before Thanksgiving. So whatever you're going to do with that hour back, have fun. And with that, I think we'll just jump into the questions. Our first question today is, our management uses a company to store boxes of past information before we went paperless in about 2019. If an association does not want to pay the $30 per month per box for this storage, can they store the boxes themselves? And the short answer is yes. Technically, the board secretary, even if you have a management company, is in charge of storing records. So you can store paper copies with your management company or at an offsite location if you want, but it's the association that is the owner of the records. They're in charge of the records, and they get to decide what to do with the records. They can be stored at the association property. They could pay to store them somewhere else. They could store them all digitally. You're not required to use your management company. You can if you want to. there's a caveat with that. Check your management contract to see what it says about storing records. But in general, an association has the right and the power to store their own records however they want and decide if they want to pay for it. The records statute, which there's basically the same for all associations, all communities, except there's a slight difference in Ukiah that doesn't really matter. But basically, Google your association statute for a list of what needs to be kept and for how long. If you have a lot of paper, like banker boxes or paper boxes full with records from 20, 30 years ago, it might be worth going through and seeing what you even need to keep. And you can reduce either how many physical records you have or scan and digitize them. An example is association meeting minutes, regardless of how old, need to be kept forever. That includes board meeting minutes. But some records only need to be kept for 7 years, like financial records, or ballots only need to be kept for 1 year. And it may be that you don't even need to keep some of these records at all. So go through your record statute, use it as a checklist if you want to purge some of these records. And then instead of trying to figure out where to put boxes and where to store them, you can just digitize everything. There is no reason to keep hard copies of pretty much anything. Anything that is a scanned, digitized copy is basically as good as the original, and then you don't have to worry about paying $30 a month per box. You could pay probably like less than $30 a month for Dropbox, and that's only one thing. So that's stuff to consider. Ken, do you have anything to add?
Well, we have had at least one client recently who had a bunch of boxes dumped in our office to allow us to go through and advise them on what they needed to save and what they didn't need to save. I think of the 8 boxes that came in, 6 of them went immediately into the shredder. And then we had a paralegal who spent a couple hours scanning the remaining documents so that the association could have them electronically. And then I assume they went to the shredding bin at that point also. Certainly not work we're looking to do, but if you don't feel like you have someone who can go through and match up the records against the list in the statute, you can have your management company or a lawyer do it for you. Second question is regarding a CTA. We came across the following guidance, and I'm wondering if you've heard of this and have any insight. The short version of this is it's a question on whether or not the spouse of a board member needs to sign up for the CTA as a beneficial owner. And the short answer is no. The board member is who is making the decisions. They are the one in control. They are the one who has to sign up for under the CTA. The spouse is not a decision maker because it is the one person who has been elected to the board. Now, the exception to that is if you are a beneficial owner because you own 25% or more of the community, which I would expect not to happen very often. If you are one of the beneficial owners because of your percentage ownership and you are married, then in a community property state like Washington or California, then you would be considered to have some control, and we would recommend that the spouse sign up. Okay. But otherwise, it's fairly straightforward. It's just the spouse who is elected to the board who would sign up for the CTA. Anything you want to add, Katie?
Nope. So the next question is, if a board denies a violation fee waiver and a homeowner asks for a hearing and the board schedules the hearing, but the homeowner never shows up, is the board required to give a homeowner a new hearing? So our short answer is probably not, but as with anything, there's a lot more information we would need to fully answer this, which we can't do in this setting. But it all boils down to basically why someone didn't show up and if you knew about it. So generally, if a person requests a hearing at a specific date, everyone agrees on the date, or the board even gives a notice that says a hearing will be on this date, and you don't get anything back from the owner, and they don't show up, usually the board does not have to reschedule and the fine is assessed after the hearing. But you need to be reasonable. So if like for example, if last night the person didn't show up because everyone lost power, a court may not see that it's reasonable to not offer a second hearing because of all the circumstances. So when offering a hearing or scheduling a hearing, we would need to know basically what circumstances are there? How much money is it about? Did the owner have an excuse for failing to show? Was the notice of the date of the hearing fully compliant with the statutory notices? And all of that is before we can advise if a new hearing should be given. We'll say if you're kind of wavering of whether or not to give a new hearing date or not, what's the risk in not giving another hearing date? That the safer option would just be to offer another hearing date instead of denying it. I also did want to bring up that the way the question was phrased is if the board denies a violation fee waiver. And the way we read that is basically the fine has already been assessed and the owner is requesting that the fine be waived. And I want to remind everyone that you need to give notice and an opportunity to be heard before the fine is assessed. A fine waiver implies that the fine has already been assessed without first allowing the owner to request a hearing. And we think that this would probably violate the owner's due process rights and would not be enforceable. So if that's your practice, maybe consult your association attorney to make sure that you are crossing your T's and dotting your I's. Ken, anything to add?
Just that, we see a lot of these issues when they come into our office for collection because the owners refuse to pay. And when we're dealing with the collections side of these issues, we have to make sure that every bit of the process required in the statutes and your governing documents have been complied with fully. Because if we don't make sure that's done, then we're violating federal law by pursuing the collections on behalf of the association. And we can't take the risk that the procedures were not followed properly. It's a violation of the unfair debt or of the Fair Debt Collection Practice Act. So that's part of why we are, sticklers on this, because the law firm has been sued in the past by debtors who went out and got an attorney, and it was all about the process. It was never about whether or not there was a violation. Next question. If it's not too legal of a response, can it be asked what responsibilities, if any, lie with the board if they know an owner does not speak English at all or very well? Do we offer to translate notices, etc., or leave it to the owner to handle their own translation needs? If the owner asks if we can provide translated documents, do we agree to do that? RCW 6490 Ukiah was researched, but it seems to be silent on this matter unless we're not looking at the right sections. So I would agree that the statute is silent on whether or not you need to provide translated records. And my short answer would be is that if it helps the association accomplish something like giving notice to owners that some inspection is going to be done, or making sure owners know when and how to increase their payments for dues, and you have a block of owners who don't speak English well, then I would say it might be worth trying to translate those notices into a language that they would understand. I probably wouldn't do it for a single owner unless it was a very specific issue. And again, it benefits the association to try and offer a translation. I don't think that a non-English speaking owner can require the association to translate records. And I would recommend against trying to translate something like the recorded CC&Rs, because I think there's too much risk that a translation is going to change the meaning in the mind of the recipient who's got the new language. I don't know that there will be exact wording in a second language for how the document is written. And it's recorded. If they're purchasing the property, they should know what the obligations are that are in the document, even if they don't speak that language. So it really, to me, comes down to what benefit does the association get from trying to translate documents? I've certainly encouraged clients to try and find an interpreter when they are dealing with something like a violation hearing with an owner. And often the owner can bring a family member or friend who can translate for them. And that has usually been very helpful because you're trying to solve a problem and communicate. So it's reasonable to ask for that. I don't think that asking the association to translate something into a foreign language in writing is the same as letting an interpreter try and help, because the interpreter can ask clarifying questions to make sure that they get the intent and what you're trying to say across correctly. Anything you want to add, Katie?
I was debating it. If you know of someone in the community who also speaks English and this a specific second language, it might be worth, like, people can always be neighborly and communicating with that, but usually a family member, typically younger family members are more likely to speak English and whatever the second language may be. So just getting them more involved, even if it's not the association providing the interpreter, being accommodating will probably help you get your goal further.
Yes, I can recall a time where I think a 3 or 4 year old child was the translator for me. We were doing building inspections and we just needed to get inside the unit to check the bathrooms. And the mother apparently spoke zero English and couldn't understand anything we're saying. The 4 year old child understood enough to be able to ask that we could come into the house to look at the bathroom. So.
Yeah, so the age, anything works. Okay, next question is, last week, or in our last Q&A, we mentioned that associations cannot retroactively basically charge dues if they do not have the budget ratification before December 31st of this year. And this person wants to confirm that if not, retroactively charging the association dues is general law, or if associations, as long as they get the notice out, can actually enforce the increase on January 1st, 2024. And they can't find where this is in the CC&Rs or any governing documents, so this is just to confirm. And I did kind of paraphrase the question, but basically the short answer is you cannot assess a new amount if the budget ratification meeting has not happened yet. It's not explicitly stated in the statute, but you would not be complying with the budget ratification statute if you charged owners an increased amount that had not been ratified. This is because, and the statute that applies for everyone is RCW 6490-525. The statute requires that owners be provided with the budget for ratification with no less than 14 and no more than 50 days of notice of a meeting. And so the meeting is a requirement to ratify the budget. If the budget is not ratified, then the prior budget stands until a new budget is ratified. And you can't increase dues without a ratification. And there needs to be a meeting. And the proposed ratification, what you're sending out to the owners, must include the assessment amount and when they are due. And the due date needs to be ratified along with the budget. You could, in theory, have the board approve the budget on December 10th and send notice for the ratification meeting to be held on December 27th or 30th. It doesn't have to be a convenient time because no owners have to attend the meeting for it to be ratified. The budget is ratified as long as it is not rejected by a majority of the owners. So if no one shows up on December 30th or December 27th, then the budget is ratified And as long as the notice of the meeting says that the new dues amount would start January 1st, then you could start the new assessment on January 1st. But if you send out a notice of dues increase on December 27th without holding the ratification meeting until, say, January 15th, our law firm would not be able to collect any increase that was imposed on January 1st. So if someone did not pay this new increased amount, we wouldn't be able to collect it. But if everyone pays, even though the process wasn't followed, it kind of doesn't matter. It's just when people don't pay that it's a problem. And the ability to collect the increase is what's at risk for failing to comply with the statute. So, like I said, if everyone pays, then there's no risk. It's when people don't pay that we start having these issues with the process that I think we talked about a little bit ago with the fines, just like fines, budget, everything you need to follow your process. Ken, anything to add?
No, I think you covered it. It's just the increase that we couldn't collect because the statute does say the previous budget would continue. So, we've had clients where they increased their dues $25 a month. They didn't follow the process. It comes into our office for collections. And we basically can advise them, well, we just can't collect that extra $25 for the 3 months before you held your budget ratification meeting in April. And some clients are okay with that. So to some extent, it's trying to balance the risk that someone's going to not pay and it'll go to collections against the ability to get this strict compliance with the statute and how it's written. So next question. Generally speaking, if an old act declaration is silent on the responsible party for damage from a unit water heater, but the House rules specify responsibility to the unit, which document would prevail? So the short answer is that the declaration always controls over rules, especially if there's a conflict between them. And then I would respond that the document is not, the declaration is not silent about damage from water heaters. It has provisions about damage. It's just all damage is lumped together the same. So it doesn't make any different exception for how water heaters are handled. And so if your declaration does not have something specifically allowing an allocation of damage for a water heater, you cannot create that obligation in the rules under the statutes, under the Horizontal Property Regime Act or the Condominium Act. Okay. So there is an exception in Ukiah, and I don't know if this is intentional by the legislature or not, but they did set up in the statute, which I'll actually talk about in a later portion, a later question, a provision that allows you to create a maintenance standard for something like a water heater. And you can state in the rules with that standard that a failure to comply with that standard may make the owner liable for damage or losses that are caused by their failure to comply. So this exception requires 5 different things. It requires first that you are a Ukiah community. So unless you have adopted Ukiah, you couldn't do this until 2028. It second requires that you have adopted and distributed properly to all of the owners specific maintenance standards for the water heater. Third, it requires that the standard states explicitly that a failure to comply may result in the owner paying for costs resulting from that failure. The statute's very specific about that. Fourth, it requires that the owner actually fails to comply with the standard. So if the standard is you have to replace the water heater at 15 years old, but it failed at 13 years old, then you could not make the owner responsible because they didn't fail to comply. And then fifth, the failure to comply has to be the cause of the damage. So if it was a washing machine supply line that failed instead of the hot water heater, you could not shift the costs to the owner. So again, if you tell me the declaration's silent, I would correct you and say there's a specific insurance provision in the declaration which says how insurance is handled. And there's almost always a specific damage and destruction provision which states how the repairs are to be handled. And if you've got any condo declaration written probably before the year 2000, there's almost a guarantee that it states the association is responsible for restoring all damage and that any costs in excess of insurance proceeds will be a common expense. And you can't modify that by rule, except as I've just noted. So the default is the HOA is going to pay it. Did you have anything you want to add, Katie?
The only thing I'll add is that the association's insurance is primary. So even if your documents say that, or otherwise silent, like I just talked about, and it says, but owners are required to have insurance for unit, personal items, whatever. The association's insurance is still going to be primary. And so the analysis wouldn't change just because there's coverage under both policies. Before jumping into the next question, I did want to give people a heads up that we will probably have time for questions. We have about 3 to 4 more that were prepared in advance. So if you want to start thinking of questions for the chat, feel free to do so. And if we don't get enough questions, then we will take it from there. So our next question is, our HOA is governed by the HOA Act, which is 6438, with less than $50,000 in revenue each year, so no audit requirement, and governing documents are silent on the topic of records requests. We received a records request for bank statements, and we are trying to determine to what degree financial records should be disclosed to any member who requests the records, or if it is at the board's discretion. Similarly, we are wondering if a bank statement is the same as a financial statement as referred to in RCW 2403A, Article 6, which talks about books and records in subsection 210, inspection by members, which all of that is about the, is under the nonprofit corporation, one of the statutes. The assumption is that the only exempt records could be those held up in litigation or other legal processes, not necessarily financial operations. Looking for any statute that might help clarify. Well, the good news is that there is a statute in the HOA Act that directly applies, which means we don't even need to look at the Nonprofit Corporation Act because there is a relevant community association statute that is applicable. So if you look up RCW 6438045, this talks about records and records requests for communities governed under the HOA Act. The statute basically provides a checklist for what needs to be retained, what needs to be provided, and what can be withheld. We think, based on the question, that financial records need to be provided. There's a pretty clear statement which says all financial statements and tax returns of the association need to be retained for the past 7 years. And later in the statute, it talks about what records can be requested, and financial statements would fall into that category, and bank statements are financial records. There's no definition that says bank statements are financial records, but I think you'd be hard pressed to make an argument that they're not. We can probably support redacting things like an account number and some other information, but you should contact an association attorney if you want to know if there's anything more specific that could be redacted. The board does not have discretion as to what it gives out when records are requested. Generally, there is, absent active litigation with the person asking, you may be able to require that person, if there is active litigation, to comply with the court discovery rule. But for the most part, the statute is a checklist, and it says what must be provided and what may be redacted. And unless you fall into one of those categories, the board has to provide the information if requested by an owner. Ken, anything to add?
Yeah, so when people say that the statute says that the association has to keep financial records, That means a balance sheet showing the assets and liabilities, and it means an income statement showing the money that comes in and the money that goes out for the association during a period of time, like a year. And you're required to keep those records whether you have an audit or not. It's just that, a bookkeeper or treasurer is keeping those instead of a CPA. So a bank statement is clearly a record, but it is not a financial statement. So those are different things. And then I would also note that under Ukiah, the timeline for compliance is specifically included in the statute now. This was a modification to Ukiah that took effect in June. I think that it says that you have to give the records within 10 days, unless the information reasonably requires a longer time. But the statute says in no event longer than 21 days without a court order allowing for a longer time. Now, the interesting thing to me in that is that I don't know how you're going to get a court order within 21 days in order to ask for more time, but that is what the statute says. So you've got 10 days to provide the records unless they are, difficult to obtain for some reason, in which case you could ask for as many as 21 days. But we see clients who will routinely hold records for weeks or months with no legitimate reason, and it's just going to cause you problems to do that. We're going to tell you in most cases that you need to just provide the records. But if you're not sure about what you're providing, you can certainly consult an attorney. The statute does have a list of exceptions to the rights of a owner to request records. One of the exceptions added to Ukiah was that uh, owners are not allowed to see the ballots for elections or for amendments which are being adopted or voted on. And that's to allow for secret ballots. And that provision was not adopted into the HO Act or the condominium statutes, but it was adopted into Ukiah this year. So that's all I've got to add. Anything else, Katie?
Nope.
Okay,
So I think
so the
you're,
next question. What course of action should an association follow if the entire board resigned due to the obligations to comply with the Corporate Transparency Act? There's no current acting board member, and their Secretary of State is also due for renewal, meaning you have to report the board members to the Secretary of State. So there's a couple things we would suggest. One is that you can hold an election and elect a new board. We would probably ask the board members to remain until at least December 31. And if they are all intending to resign because they don't want to provide their driver's license to the Department of the Treasury, then you should ask them to appoint new board members before they leave so that you don't have no one capable of acting for the association. Or you should ask them to call a special meeting of the association in order to elect new board members. Basically, you can have an orderly transition from a board that is not willing to comply to a board that is willing to comply. And you've got 6 weeks to do it. It doesn't require more than the board simply holding a special board meeting to appoint those new members. Okay? But we'd also sort of remind people that this is not new information that you're giving to a government that doesn't already have it. You're giving it to a different department. You're giving it to the Department of the Treasury or the U.S. Treasury for the purposes of the Corporate Transparency Act. But, the state's already got your driver's license. The federal government already has records of you and your social security number. When I went to sign up to get my FinCEN number, it asked me for my login, and it turned out that just because I had signed up to get my social security statements online, I already had a federal government ID number and a password. And I didn't remember I had done that, but when I asked it to sign in, it said there's already a record for this email address. And so it sent me a resetted password. And that's when I learned it was because I'd signed up for the Social Security statements. So this information is not something which is otherwise secret. You don't have to share it um, with your fellow board members or manager or owners. It's the way it's set up is you can get a number from the Treasury Department, and then the association simply provides that number to the FinCEN report. Anything you want to add, Katie?
I just want to reiterate that it's really not that complicated. And I know Ken just said all of that, but like, I mean, people can resign for whatever reason they want, but I don't know if it's, in my mind, a good enough reason just because you don't want to provide the government with information they already have to resign. But again, people can resign for whatever the reason they want. Some states have held, not Washington, but that the last standing board member can't resign if it would leave the association with no board members. Again, it hasn't been addressed in Washington, but that's something to keep in mind. Basically, just have the last person appoint people before everyone resigns. Don't all resign at once because it kind of screws the association. There was kind of a question that came in the chat that is somewhat related to this, and I think we might as well just talk about it at the same time in terms of board members. It's, how do you recommend an association move forward with only one board member and no owners willing to volunteer? If all board members resign, does the association automatically go into receivership status with the state? And what does that process look like? And so I think we did touch on with that last question of what do you do with only one board member? And that's, the one board member can appoint, either call a special meeting to hold an election, which might be hard if there are no volunteers, and or appoint people to fill the unexpired term until the next election. And again, both of those require people to volunteer. So if no one's willing to volunteer, it might be worth emphasizing how expensive and difficult the receivership process is, and try to encourage people to volunteer for like a year or something short where they don't feel like it's a big commitment. Ken, do you want to talk about the receivership part?
People have this idea that somehow the board resigns and a receiver is appointed by the state. That is not true. To get a receiver, you need a lawsuit and the court to appoint a receiver to manage the affairs of the association. The lawsuit means you have to sue. Somebody has to sue, and they are going to sue every member of the community. So if you've got a 100-member community, you're going to have to serve 100 people into the lawsuit, and you're going to have to get in front of a judge and ask the judge to appoint somebody, probably an attorney or a professional manager, to function as the board of directors. It can't be the manager of your association because they are not making the decisions on that the board makes. It has to be a separate decision-making person. And you'd also be paying the receiver probably in the $300 or $400 an hour at least to perform their duties. So it is an enormously expensive process to initiate. It's going to take time. It just doesn't happen. And I've actually only seen one receiver appointed for an association before, and it was because the developer still owned more than half the units and it went into bankruptcy. The bankruptcy court appointed a receiver in order to serve as the board. So basically the short and the long answer is, if you care to resign, just find somebody else to take over the responsibilities. And if you don't care how the community is run and are willing to resign over having to provide your driver's license to the Department of Treasury, then I guess you don't care who manages the affairs of the association and what they're going to do. So just let them do it. You know, there's almost certainly to be someone who will be willing to serve because they get to run everything.
True.
I did
Okay.
see a chat question come in, which is easy to cover, which is there a timeline for the management company to provide records to the association if they're asked? And that is in the statute. It's in Ukiah specifically that the management company has to provide the records within 5 business days of the termination or a board's demand. That's all electronic records have to be provided within 5 days, and all written records have to be provided within 10 business days. So that is in the statute 6490, 495.
Yes.
All right.
There is a clarification question. I think there are some issues with some multiple because it's about receivers. So to clarify, if there is no board and no one volunteers, the HOA stays stagnant until a lawsuit is filed or owners volunteer. I would say yes, because there's no one to run the board. But the follow-up question is what happens to their bank accounts and funds?
Well, if there is no one who is authorized to manage the bank account, the bank just has to hold them. And there certainly have been cases, and I've seen these, where the bank doesn't know who can spend the money. So the bank will file a lawsuit to have the court tell them what board member or owner is authorized to withdraw funds from the association's account. If a management company has been in place and was authorized by the board to pay bills like electric bills and sewer bills, I think that the manager is safe in continuing to pay bills for necessary services like water and sewer and probably insurance. But I've also advised in that case that I think the manager can call the special meeting of the owners to try and get a board member elected. So I don't think that the management company is paralyzed to do anything because the board has gone away. I think that they do have to take steps to either get one of the original board members to appoint a new board member or call a special meeting in order to elect a board member who will serve.
Okay. Back to our regular scheduled programming is the next question is, can I ask your opinion on anonymous ACC committees? Nowhere in the governing documents does it state the committee needs to remain anonymous, and I have some concerns with this process, but I wanted to check if you had an opinion. We can't think of a reason to have an anonymous ACC committee under pretty much every statute, and especially Iowa. The board is the entity that appoints the committee members, and that is done at a board meeting and should be reflected in the meeting minutes, which is all not private. It's public knowledge. So there would be no way to be anonymous. Under Ukiah, if the committee is acting with board authority and power, the meetings must be open to the public. And so then you wouldn't even be able to have an anonymous committee because people would be able to attend. We don't think that anonymous committees are, I made a long list, realistic, reasonable, or even supported by anything. If someone serving on the committee doesn't want their committee involvement known, then maybe they shouldn't be on the committee. We did have some discussion is if you're trying to avoid having a specific person being targeted or basically blamed for a decision that an owner doesn't like, you could explore having a panel of 5 where only 3 people will make it a decision on one thing, and then that way it's the whole group getting blamed instead of a specific individual. But in most cases anyway, regardless of who's on the committee or if it's anonymous or not, a decision of the Architectural Control Committee, which is the ACC, would be appealable to the elected board, and then that board decision would have to be public. So basically, probably not. You can't have an anonymous ACC committee, or at least in the end, the decision is not going to be anonymous or private. So you might as well be open. And I will say that we've seen with Ukiah, the legislature is favoring transparency. And so while it's not specifically addressed if you can have an anonymous committee of any type, I would say that the statute and the legislature are leaning towards no. So I wouldn't recommend getting in a practice of having this anonymity, which is contrary to what the legislature's intentions are moving forward, because it's not sustainable. Ken, do you have anything you want to add?
Yeah, I'd say if your governing documents provide for an anonymous ACC, you'd want to have them reviewed, or I'd want to see them before I could give actual legal advice on it. But I agree with Katie that I can't think of a good reason or one that's supported by the existing statutes that you could have an anonymous committee of any kind, whether it's ACC or anything else. Next question. If a condo suffers an insurable loss due to an owner's negligence, is the deductible paid by the association and then damages sought from the owner, or is the owner required to pay the deductible and money is ever paid by the and I guess the money is never paid by the association. I think it's a typo. I think it'd be good to remind people of the various sections of the declaration that would matter, upcoming due process requirements under Ukiah that would be applicable to everyone else. So we've already discussed this some in our question number 6, but the idea that a negligent owner has to pay the deductible is not supported by law. It may be supported by your governing documents specifically, and we talked about how there could be an exception if you have a specific standard for maintenance and the owner is negligent in failing to comply with that standard for negligence. But otherwise, the damage and destruction provisions of your document, which are the ones that control who pays for uninsured losses, in almost all cases, the older documents are going to state explicitly that it is a common expense, and some newer declarations and on many amendments that have been done by associations will state that the negligent owner has to pay for the deductible. So things you want to look at are the insurance provisions in your declaration, and the damage and destruction provision in your declaration. These are going to control over the maintenance provision, because if you've got a damage event, that is not the same as an owner maintaining or replacing their unit. So if the hot water leaks and damages the floor, you don't go to the maintenance section which says the owners maintain their own floor. You go to the damage section because you've had a damage event, which may say or likely says that it's a common expense. So the relevant portions of Ukiah that would allow for assessing the cost for negligence to the owner are in 6490-480, and they're sections 6 and 7. And this is where it states that the failure of an owner to comply with the maintenance standard that is prescribed by the declaration or a rule is the basis for assessing the cost. Now, that's not the same as negligence. So if the owner was negligent, but it wasn't based on the standard, you don't get to use it. So if they plug up their bathtub and overflow the bathtub, and you don't have a standard for that, then your declaration language controls. And if it doesn't allow you to shift the deductible, you can't shift the deductible. there is this idea that under tort common law, that you can make a negligent person pay for damages. And we have never seen a case that has supported that in the condo situation. There does seem to be in Ukiah and in the Condominium Act a provision that allows you to assess costs for willful misconduct. Now, willful misconduct is different than negligence, and Ukiah does not require that that be contained in your declaration. You can assess costs to a owner for willful misconduct, even if the declaration is silent. But again, you can only do it for an amount up to the deductible under the association's policy. So I kind of feel like we're repeating ourselves a lot on this issue. If you want to have a result where you can charge a negligent owner, then amend your condominium documents to provide for that result. You don't get it just because it seems like the right thing to do or it seems fair. Anything you want to add?
Nope. And so I think let's just jump into some of the questions from the chat. The first one is when we were talking about document storage. This came in. Can a document scanning service be used, probably to digitize? I would say yes. I mean, I don't personally have an industrial scanner at home, so if I had a lot of records, you could use a document scanning service, or the management company may have a more industrial sized scanner. I know we've let some people use it. Short answer is yes, but keep in mind the document scanning service will not go through and tell you what you do or do not need to keep. So that's not a substitute for actually looking at them if you want to. Ken, do you have a different opinion?
No, I think it's fine to let a service or an owner do the scanning. When we talk about an industrial scanning machine, it's just a copy machine.
Right.
Almost all photocopy machines that are new are actually scanners because they do a scan of the document and then they print it. So the copy machines we have in our office will scan both sides of a page at the same time. They have an auto feed function. They'll save it to a file folder, which you can put onto a flash drive.
Right.
So the bigger problem is not the scanning, it is the opening up each one, seeing what it is, and renaming it so that you know what it is and can find it later. And so, we had a client that brought in 32 boxes of documents, and the board president spent, I don't know, 5 or 6 evenings scanning what was needed into file folders. And I don't know how many days she spent at home going through renaming each of the file folders, assigning a date to it so that it was in a form that they could actually retrieve a document when they needed it.
I'll also add that you could probably go to like FedEx. I don't think Kinko's, I think it's FedEx Kinko's, or like Staples, and they probably have some sort of service if a board member just wants to dedicate a few evenings to do that. The next question is, what can you do as a manager if that board does not engage the issue? And I think this was when we were talking about the first time with the deductible and water heaters, but I can't be sure. Yes, I am correct. So what does the manager do if the board is not engaging?
You simply have the repair expenses within the deductible come out of the association's bank account. And if there are not adequate funds, and I've had that happen to a couple clients this year, then you may be able to borrow from reserves, which requires that you notify all the owners and tell them how you're going to deal with it. Or you do a special assessment to the owners in order to collect enough money to pay for the repairs.
Yep. Okay. The next one is, I think we kind of talked about this, but I'll just repeat it just to make sure. Can the state assign associations at risk of receivership to their current management company? And as we talked about with receivership earlier, there needs to be a lawsuit and it's against all the owners. So the state is not going to just do anything without the prompting of a lawsuit, and then it would be the court. I don't know if there's a lawsuit that it could be made to the current management company could be the receiver, but I don't think so.
It's unlikely that the current management company could also be the receiver. There's a reference to the Secretary of State being allowed to appoint a receiver for a charitable nonprofit corporation. So if, the Salvation Army suddenly did not have a board of directors, then the Secretary of State can appoint a receiver to operate the Salvation Army because it assumes they have assets and a charitable purpose. Homeowner associations don't qualify for that, and the Secretary of State is not going to get involved.
Okay, so the next one is, does one divide the percentage of ownership for the board members by the number of board members for the CTA or an HOA? I think this is asking about the 25%.
Well, I'll say no. The board members' percentage of ownership has nothing to do with their obligation to register under the CTA. All board members' votes are equal, regardless of the percentage of ownership each board member has. The second requirement for the CTA is if one owner controls 25% of the property within the community. And then it doesn't matter whether they're on the board or not. They still have to also provide information. It's an uncommon circumstance where one owner would own 25% of any large community.
Right. Okay, so there are two questions that I'm going to combine because they're basically the same topic, which is, can the HOA dissolve the HOA and the CC&Rs, and then can a small association dissolve their HOA, and would it cost so much that no association elects to go that route?
Well,
I'll say, if you're thinking of dissolving your association, you should consult your association attorney to determine how much it would cost and if it's even possible.
yeah, it really depends on the kind of structure your community has. If you are a community of single-family lots and you also have common area, you cannot escape being a homeowner association because of the commonly owned and maintained property. If you're a single-family community with no common areas, no commonly owned road, no wetlands, no retention pond, then it would be possible for you to terminate the CC&Rs with an adequate vote of the owners. It's usually in the document how you terminate it, but then you don't get any of the restrictions on the property that would be provided for by the CC&Rs. So it's in theory a trade-off. You're giving up some protections and giving up the obligations. If you are a PUD or a condo form of entity, then it's almost impossible to eliminate the HOA because the county land use codes will not allow each of the properties to be owned as single-family homes. So in theory, sure, you can get rid of an HOA. In practice, it's almost impossible because the HOAs own land or the HOAs are formed using a land use code that required the condominium or PUD form of a structure.
All right, so we are right at 11 o'clock. If we did not get to your questions, please send them to info@condolaw.net so we can get to them next time, which will not be next Wednesday. It will be the first Wednesday of December. Thank you, everyone, and have a good day.